We're good. All right, good. It's an honor to be here, and I'm really excited because the last time I was here was December for the appellate training, and I had to take the elevator up because I had broke my leg and my knee. So when you see the stairs, when I saw the stairs here and knew I could walk up them, I was just extremely excited about that. So it's good to be back and on both feet. So I have been in this position since the end of May, so about 10 months. I've greatly enjoyed it. While I was at the governor's office, I served as the liaison to the public defender's office, the board of parole, and the ethics board, and a few other state agencies as well. And also on top of just day-to-day legal issues that an in-house counsel would receive, and then reviewing all legislation. I served as, we call it the clemency attorney, but it'd be the pardon attorney. So I visited all the prisons and dealt with people out of prison trying to get their firearm rights, voting rights back, and then people serving Class A murders in prison. So that was an exciting part, and I've enjoyed this role as well. It's been a busy 10 months. We're also real busy with session. I will try to answer your questions the best I can, but my experts are back in the office right now, so I will try to make sure if I can't give you the answer that I give it to you right away as well. So just a very brief overview. I was given the task to just kind of let you know, introduce myself so that way you knew who I was, and please stop me afterward or shoot me an email or give me a call. I'd love to meet you. But just a brief overview and sort of the things that I would like to try to implement during my tenure as the public defender. So the mission statement of our office is that we provide high quality legal representation in the most efficient manner. We have two systems. Most, I believe all of you, if not most, serve on one side, and then we have the other side. So the one system is our public defender system, and those are state employees. We have room for 223 full-time employees, and about 150 of them are attorneys, 25 investigators, and then 45 secretaries. And they're in 18 field offices in 13 cities throughout the state, and that's $25.5 million budget. So the two budgets together are about $60 million. They used to be about half and half, and indigent defense side is now a little bit higher than the public employee side, or the public defender side. Right now we have roughly about 24 vacancies in the state public defender side. And there's a variety of reasons for that, just retirements. We've had a couple people appointed to judge and a few people just moving around. And so with that, I'm sure you guys are seeing that a lot of the cases being sent to the public defender side are on the higher side. And you probably also see that we are just doing a lot of hiring. And so we kind of have been doing that since, I would say, definitely since December. And then if that vacancy, if it was internal, led to another vacancy, that leads to another posting. So there are just, we're busy on this side, both with cases and then from administrative level, recruiting good people for those positions. On the indigent defense side, usually we hover north of 810 contract attorneys, and those are throughout the entire state. That is a $35 million budget, and so you can I put the breakdown of where those claims are. So the big chunk of it are the adult criminal, and then you go down to juvenile, miscellaneous are experts, and then appellate is the smallest chunk of that. And so you can kind of just see this year our budget was 25 million, and then 33.9 on the contract side, which was just shy of 60 million. For fiscal year 18, the legislature's not done. They have not acted on any of our budget for both. There may be a de-appropriation for our current fiscal year. The governor proposed $236,000. And then on the contract side, we were projecting a deficit. And so we want to make sure that you guys get paid and get paid on time. And so the governor proposed a $2 million supplemental appropriation. And then the one side, the state Senate proposed 1.7 million, which we would be able to cover that. So there's no budget concern. We're able to, last year we took 4 furlough days. 1 day was coincide with the court. We will be able to make that through this year without any furlough days. And then for the next fiscal year 19, which would start July 1st, the governor increased our proposal for the state public defender side, and then increased the Indigent Defense Fund as well. So that way we always try to get through without doing a supplemental. The caseloads. So we've been busy. You've been busy, we've been busy. So on the public defender side, and one thing, I find it intriguing. I don't know how many other people do, but we track the cases differently. And so when we track the indigent defense side, we call it officially a claim. And what a claim is really, it's your case. And so if your client had 19 charges, that just counts as 1. And so we pay you as that. On the public defender side, we track their charges. And so when we handled 83,398 charges, and you guys and the contract attorneys handled 76,734, that is not an apples to apples comparison, just because a case, the number for the indigent defense side would be bigger, just with 800 contract attorneys and only 149 attorneys. So what we're trying to do is also try to look at our systems. We think we'd be able to make better decisions, and if we were able to track both sides the same. So that is why there's a distinction there. And for 2017, we were really high. 2015 was higher on the public defender side. On the indigent defense side, you can see there was a significant jump, and part of that jump was due to the Young decision that the Supreme Court in 2016. So it is helpful now. I mean, every time you have a different law that maybe will expand the type of crime or add a different crime, or if there's something, a Supreme Court ruling that might change our budget as well. But it's always good to kind of look and get a feel of this is where we are. So that way you can kind of see a trend line as well. Serious crimes in Iowa are up, and they're significantly up. And so for 2017, we've had 120 Class A disposed charges with just north of 40 convictions. Homicides in Des Moines are up. And so 2015 was the second highest year with, I think, about 21, 22 homicides. And this was taken, I believe the snapshot was end of October, early November. And so it was at 25 in Des Moines. And that correlates to our budget. We are a responsive agency. We don't determine who commits the crime, if a crime is committed, or if prosecutor decides to charge. So we're reactionary to that, and so we monitor those issues as well. Another trend line that we see up is the number of defendants being charged together is up. Gang violence is up, especially on the east side of the state, and so our Davenport office was assigned to, I believe there were 4 co-defendants in a murder. And so our office usually will only handle 1 defendant, and so that means we have to find attorneys for the 3 other attorneys, or for the 3 other defendants, excuse me. So we see that a lot in Burlington as well. So we try, as public defenders offices, they do try to manage and maintain a lot of the Class A felonies, but we have been sending them out to the private bar, especially due to the increased number, and then also when we have multiple co-defendants. Sure.
Are you doing anything outside of those cases you just talked about to shift those, like Class A's in particular, to the private bar, just to keep enough of us competent to do it?
You know, the number to ship out to keep them competent. The number one priority that we look at before I arrived was that the public defender's offices did try to maintain the most expensive cases. And so, and then we started the second chair program. And I know sometimes with the second chair program as well, for less experienced attorneys, they can sit second chair sometimes to a public defender as well. With shipping out cases, again, our top priority is to make sure it's in the most cost efficient way possible. So shipping out cases to keep the private bar competent, you know, it is a hybrid system. I think it works well. We've been shipping them out more just due to the conflicts and the caseloads right now. So that is the top reason there. As far as contract attorneys maintaining being competent, that's something we can take into account and look at to make sure to work with you on it.
The reason I ask is because I practice in Sarasota County, and I cannot remember the last time any person outside of the public defender's office took Class A felony.
Sure. And from the public defender side, that that is a positive thing, and from one side, but it is a hybrid system. It's a relationship, so that's something we take into account. The other thing that we look at as well is it's county-based. If you are in my Waterloo office, you have done quite a few trials. In my Davenport office and other offices, a lot of cases settle as well, and so that. That's based on the county attorney and just the facts of the case as well. So those are some issues that we're aware of because people are trying, where they can get the courtroom experience, and that's just something that is based sort of geographically and the facts on the case. So I appreciate you bringing that up. Yes. Oh, okay.
Let's assume that you have a conflict, you've got Class A, all right, and you bring in some pretty heavy hitter people that you appoint. There's two that are appointed. Are they paid through your system? These are private attorneys, court appointed. They're paid through your system, correct?
They're paid. Well, our system. I want to make sure I understand our system.
You've got your public defender offices.
Correct.
So let's assume that you're not having the public defender, and I'm just using a Class A because
sure.
You see prominent attorneys doing court-appointed defenses of murder trials.
Correct.
Okay. They're paid through your offices as court-appointed private counsel, so they're part of your fund and part of your statistics, correct?
They would be a part of the Indigent Defense Fund.
Okay. Step two. Do you have, and this ties in with the maintaining competency, the county attorneys had the benefit of an Iowa criminal law handbook, which they then made available to everybody in the state. You just pay it. You got 6 months on it. It's a wonderful document. The people that do this do a great job, but it's a huge wealth of information. Do you make that available to all your public defender offices? And do you have your own internal seminars, that type of thing? And do you also make those available to your contract lawyers? Now, that's kind of a complex thing.
Sure.
If you know what the Iowa criminal law handbook is, and a lot of people do, it's just a wonderful document. And is it Pete Gray? Is that right? Yeah. Anyway, the guy who heads this up does a splendid job.
Sure.
For the state, but he makes it available for everybody.
Sure.
Now, do you have those internally generated, like county attorney associations, where you have, here's how we do our sex abuse cases, here's how we do our, that data bank and those seminars, do you do those within your system? Like they do for county attorneys through the State County Attorney Association?
Sure. And it sounds like there are a few questions in that question. So
so
I want to make sure I understand that. And you jumped a couple slides ahead of me. One thing we do is we offer, and I'll get the number wrong, but it's north of 70. We offer free trainings throughout the year, and that was something implemented 2 predecessors ago, and we have skyrocketed from about 40 hours of free CLEs. Now we're about 76. maybe 72, 74, 76. And so that is something that we offer as an office. We do a lot of webinars. We do at least one a month. And again, that's all free. And then we have implemented new attorney training, juvenile training. When I stated before with when I had my broken leg, we did the appellate training, we do the PCR training. And again, that's all, I don't want to compete against the state bar. I don't know how much you guys paid to be here today. It's great though. So I don't want to get my host mad. But we offer it all free. And even the Public Defender Association does a roughly 2.5 day training as well. I paid for it. I think it was $30 or $60. So we really work hard to make sure the training is available there. I want to. Sure. Sure.
Do we have that same kind of access to private attorneys who do court-appointed work, or is it just within the public defender's office, or does it even exist?
Sure. You know, I know there's something on our website. There are a few standard things on our website. I don't think it's at the same depth as the County Attorney Association does. That's something that you know, I can certainly follow up with John. I'll take a look at where it is on our website. One thing that I am building that we'll get to is the immigration resources. We are putting practice advisories. We have, I believe, 13 on our website, and providing free a resource that our public defender attorneys, we have 2 right now, Iowa City and Council Bluffs, that they will serve as a free resource. So if people want to email or call them, their name, number, and email address are on our website. So that's a specific area. As far as forms and blanket motions, I know there's something available on our website. The depth, I wouldn't be able to tell you on that, but that's something I could look into. Okay. Yep.
Kind of a nitpicky question.
Sure.
I think it's indicative of maybe the rub between the contract attorneys and the public defender's office that we've seen in the past.
Sure.
When we know that we're going to exceed the fee guidelines, we have to file a motion.
Correct.
To exceed the fee guidelines. That's a requirement.
Yep.
Okay. But we don't get paid for it. How come?
So sometimes I want to be, so the standard we have is our attorneys will pay for what is reasonable and necessary. Now, when the court, you have to submit your order that the judge approves. Then our office still reviews that. And so sometimes they do get paid. Sometimes maybe our office will determine whatever was filed was not reasonable and necessary. So I mean, without knowing the specific facts, but I know it's a blanket rule, we do allow payment if when there's an order to exceed. They will review that if it's determined reasonable and necessary. I know sometimes that's not the case, but sometimes it is.
I have never had one approved.
Okay.
Maybe I'm doing something wrong, but.
Sure. Yes. Oh.
In particular, they'll pay us if we get the order to exceed.
Okay.
But they won't pay us for our work, even though we are obligated to file that motion. And if you include that in your claim, they will deny it.
Okay.
Send it back.
Okay.
So I guess the question is why, if you guys are requiring us to file that and
Sure.
get that order, and it's taking work out of our time, why can't we get paid for the half an hour that we spend doing it, or whatever time we spend on it?
You know, and those, again, 2 predecessors ago, we try to work really hard to at least put what was compensated, what was not compensated, how much time in our administrative rules. So I know some of those policy decisions were made a couple years back, and you know, I understand if people aren't happy about that, but one thing that is important to me is transparency that you do know that in advance, so we're not playing gotcha in the back end or something like that. So, I mean, I understand that. Those rules were in place was we do have a limited budget. You know, we are trying to get a supplemental just to be able to pay the bills we have through June 30. So that, you know, that's something we're working on, but I appreciate your concern and comment, and that's something we can take into account. Okay, I promise you guys, my slides are really good. So if we want to keep going. And so I kind of briefly, so 18 field offices. And one thing I'll say about this is we did have 19 field offices. In the late summer, August, September, we did close our Fort Dodge office. We had 3 attorney vacancies, and within an hour, within a 2-hour radius, we had no applications for the Fort Dodge attorney positions. We had, at the same time, we had an attorney position in Iowa City, and we received 17 applications there. And so I know the Bar Association has worked very, very hard on this. The court has worked very hard on this, on where attorneys are in the state. We benefit a lot on the public defender system. We have an office in Story County. We have an office in Marshalltown as well. And a lot of times people will live in the Des Moines area and, you know, will make a commute to work or something like that. So that was really just the basis there. It's not, nothing's permanent. We're always looking for that. Our clients do go, you know, they go throughout the state. And so that's just something we're looking at there. But again, that's why the hybrid system is so important, that it is something that does work in Iowa, that we do work together. So that was the reason for there. Yes?
Is it your goal to reopen the public defender's office in Fort Dodge? I mean, I assume there's criminal conduct occurring in Webster County.
Sure. You assume correctly. You know, my goal always is to evaluate the system to see what's most efficient. And so it's certainly something that at the time, that was the decision that I made, just because I can't I can't hire someone who didn't apply. And so I have a lot of great authority in this job, but that's one thing I don't have. And so to look in the future, is that something that will always be evaluated, just on a constant basis to look at that. And then the other thing that did close that I hope, this is for our Polk County attorneys, is that one thing that we do for Polk County that hasn't been done in any other county is that we do schedule the depositions of both the public defender's office and our contract attorneys just in Polk County. That's something that was worked out years and years ago. We had a full-time employee that did that out of the Polk County courthouse. That employee left. And so now our Des Moines adult office, instead of hiring another person, they have absorbed that duty. I haven't heard any complaints or problems with that process. So that is one thing there. And then lastly, one change that we made that I know you received a letter about was an administrative rule change. So that was the 45-day rule. So claims must be submitted within 45 days of the date of service, or in the case of a judgment of conviction within 45 days. So generally, the date of service will be when the case is finished or disposed of. Date of disposition is considered to be the file stamp date on the final order. Before I arrived, I believe it was, I want to make sure I get my years right, but I believe it was November of 16. The Supreme Court changed their rules of criminal procedure, stating that when your client was convicted, you had to stay on for 30 days for that appeal process. And so what my predecessor did, effective in, I believe it was effective April of 2017, was he extended that date of service. And so that meant the date of expiration of the time for appeal from a judgment of conviction. And the reason for that, one, I don't think it was as publicized as well as maybe it could. And the reason for that, and the reason why I know that is very few to no attorneys were submitting their claims then. And so what we did was, instead of starting instead of to teach you guys the hard way by rejecting those claims, we didn't want to play gotcha. And so what we did was we sent out a letter to everybody explaining that process, that the rules were on the books. Our rules, again, are just there to mirror what the Supreme Court did, because we wanted to be fair rather than give you only the 15 days. We wanted to give you the 45. And so that was the reason for that. We got a lot of questions. I know people wanted to email what their understanding was, just because it was a change. So it did go into effect, over a year ago, but I know the letter, which was outlined, that letter's on our website as well. If you have questions about that or questions about anything, I encourage you to ask our claims email address. That's something we monitor to make sure that people get a response within 24 hours.
The effect of that is simply we only have 30 days to pay.
That is the effect of it as well. And again, I think when it was, I can't opine as to the rationale there. And one thing that we did have was a change to the date of service. So the claims really stopped in June. And so it pushed a month of claims. Our fiscal year ends June 30. So it pushed a month of claims a month into perpetuity. So last year, our indigent defense budget was really only 11 months. So this year, our budget's going to be 12 months. If I was to change that rule back, that would change the date of service, and we would have an indigent defense fund of 13 months. So that's something I took into account as well, just because it seemed like people in practice weren't abiding by it. But again, I think the intention was to be fair to attorneys, just to give them that 45 days. But I appreciate that thought. That's a valid concern as well.
Can I ask you another question about that?
Sure.
Date of service for deferred judgment. Is it the date of the deferred judgment, or is it the date for discretionary review? Because there's no right to appeal a deferred judgment. So how are you interpreting that?
So that is for convictions, with adult convictions. So I do believe the answer to that is the former.
Which means it would start on the day you got the deferred judgment.
I believe that. Yes.
Why, when you file, and I understand the 30 days with regard to the appeal time, but if you file a notice of appeal within 7 days or whatever, why isn't that the date of service?
The date of service, what our rules tried to do was just mirror what the Supreme Court changed. And so it had the attorney on for the 30 days. And so that, I believe, was the rationale there. It's difficult for me to explain the policy decisions there, but I think, again, they were trying to be fair, but that is a fair, I think there's a little lack of flexibility in there, but I certainly understand that. Okay. And so to the question that was asked before, one thing that we've done is since 2014, we implemented the free CLEs and trainings for our attorneys. So that has increased from 56 free hours in 2014 to over 75 last year. So 61 were in person, and then 14 were done through a webinar. The other thing that we have done that seems to be working well is the second chair program, where an attorney can obtain the credits of jury trials if they sit second chair for an attorney. We don't pay for that, and that can be both a private pay jury trial or one of our cases as well. And again, the other thing is we try to, any question you email our claims email address. We work really hard. Hey, Joe. We work really hard to make sure we respond within 24 hours. And then one thing with electronic claims, it was mandatory in January 1st of 2017, was how quickly we process claims. So in 2014, we averaged days of 35 to pay. And then that was cut in half to 16.8 in 2017. So that, again, the mandatory online submissions was in January of 2017. I'll just be honest and transparent. From what I hear, people like it. I think it was great timing from our office that it was at the same time as EDMS, that it was a transition that attorneys were already going through. And so it helped just to kind of do it all at once. If you do have any concerns or questions about the online process, again, email our claims email address. Mine is just ljohnson and then the same at spd.state.ia.us. One thing that we will be implementing with technology, if you've ever launched anything electronic, our rollout date has moved back since I've been here. So we're hoping for summer of 18. And so what that is going to be our miscellaneous claims experts, court reporters, interpreters. Those are individuals that are supposed to be filing their claims themselves. And so that's going to be electronic as well. And we're going to start off the same way where it's not going to be mandatory. It's going to be a phased rollout. Looking ahead, as I stated, that data system, just to make sure we are able to compare the indigent defense side and the contract attorney, and the SPD side together. We continue to make website updates where one priority is to upgrade the resources on our immigration tab under defense resources. And then one long-term goal, there's no date here at all, but we'd like to make the contract for you electronic as well. We'd like to have attorneys with our office to have one profile. So that's sort of a goal that I would like to do. I know we had a staff shortage when I took over, and the contract side, I would say, was delayed and difficult. I do apologize for that. We hired a new employee that started a month ago, and I really hope that a lot of your contract issues with regards to amending your contracts, renewing your contracts are handled in a more timely fashion. So if there's any, on a go forward basis, any issues or something like that, please never hesitate to let me know. And so the goals, as I was asked, looking forward, we're going to continue. That is a priority to train in CLEs at no cost. One, we have done most of our in-person trainings are in Des Moines. We've done some in Iowa City. We received comments, hey, can you come up on the north, come up to the north, come down to the south. That is something we're looking at. We have that. It's a good suggestion and something we'd like to implement. We're going to continue to work on our website and make sure that you guys get the answer you ask us in a timely fashion. We do want to be a resource for you, and the only way we can do that is if we give you a timely and accurate response. And then the other thing is, and I see Sharon here who has one of our contracts, we do have specially negotiated contracts as well. A lot of those are in our specialty courts. So we have Too Good to Lose, which is a great program offered in Polk County. And then a lot of them are our mental health court contracts and our drug court contracts. And so we post those, and what that is just we assign with the specialty courts. The court informed us a few years back is, hey, we'd really like just one attorney in the courtroom that gets that number of how many defendants there are. We look at if we were to pay a contract attorney, how much we would pay, and then we negotiate a rate with that contract attorney. So they handle that. I think it's a way to add value to a contract attorney in the sense of they know how much they're going to get paid. They get paid on a monthly basis, so they don't have to wait till the case ends. That's something that we can, there's some savings for us. That's why we do it. But I do think there's some value that's added to the contract attorney. And so we're going to continue to look at expanding on that. Yes, sir.
We had 3 contracts exactly like what you're describing in Sarasota County, starting back in 95 roughly, ran through 2004. The public defender's office canceled them and refused to pay them.
Well, I was a sophomore in college, so I won't be able to give you any historical information from 2004. And so I could tell you about Purdue's football season, but so I can't opine on that. But what I can say is, looking at the contracts we do have now, again, I mean, I could look back historically, we do have some of our attorneys that were there as well. I wouldn't know that. That was 4 or 5 predecessors ago. So I wouldn't be able to opine to the specific facts of that case. But what I can say is that we work really hard with the contracts we have here. They're state contracts. I sign them, so they would be enforceable. I personally sign them myself, and with those negotiated rates. So I mean, so if you see a posting, I do think it adds value. It adds value to the legal system. I do think there's a lot of benefit. I think specialty courts are really a great thing. The drug courts, the health courts, the too good to lose court. I don't know the status on the veteran court. It costs money for the court, and so they are budget conscious as well on their side. But it is something that we support and try to work with that, because I really do think there's a lot of value added to the legal system. So if that's something of interest and you see that posting come in your county or in an area you service with, I encourage you to apply. And again, that's something that we may be expanding the type of contracts that we do offer. And I don't know what happened in 2004, but I can say that we do honor the contracts we have, and we have a really good working relationship with our especially special contracts. So sorry that happened, but I wouldn't be able to know what happened then. And so with that is what I have. I think that's my time, John. Okay.
I have one more question.
Please.
So, like, for example, recently, I know Mike will know this too, in Algona, there was a murder charge just a few days ago. With the closing of the Fort Dodge office, I think the closest office to that area would be like Sioux City, which is, I don't know, a good hour and a half, 2 hours. Maybe the Ames or Story County would be closer to Algona than Sioux City would, but not by much.
Sure.
How does your office deal with that? Do you send somebody from the Sioux City or the Story County office to cover the gap that was created from the Webster County office? Or can you explain how that works?
Sure. So on our website is our designation chart. And so what happens is we have a presence for all Class A felonies. So sometimes some counties, we may not even touch misdemeanors or even some Class B's, C's, or D's if they're too far. But based on whatever the charge is, what the court would look at and our office would look at is, okay, and then we have backups. So sometimes I wouldn't be able to tell you off the top of my head what the procedure is for Algona, but it is on our website. And so if it's a Class A, they would look and send it to this, whatever designated office it is, whether it's Sioux City, Mason City, or Nevada. I know Waterloo has taken some of the Fort Webster area as well. And then if they can't take it, they look at the second designation. We do have the Special Defense Unit, which is housed here. They primarily do the sex offenders up in Crusoe, but then they are everybody's backups. And so they will get they're kind of the road show. So they're all public defender 3s in that office, and they're qualified to handle Class A felonies. So they would get that as well. So sometimes there may be just 2. We go up to 4, maybe 5 offices depending on the county of where those backups are, and then it gets sent to the private bar. So you can just kind of follow it along on the chart. Yes.
I had a question about interpreters.
Okay.
So interpreters get a higher rate of pay per hour than we do, as well as they get paid travel time.
Mm-hmm.
So I'm in the 4th Judicial District, so sometimes they bring interpreters from Des Moines, so they're paying them 4 hours travel time at their higher rate, in addition to the time that they're actually at the hearing, which I believe is they also have minimum times that they use.
Sure.
So we are having out there attorneys like myself who can't afford to go and travel to some of these other counties outside of our home county because I don't get paid the 2 hours each way to
Sure.
do that. Is the state looking into that at all? I mean, are you guys taking that into consideration that we're having attorney shortages in some of these counties because we can't financially afford to just have dead time in the car? Meanwhile, you're compensating interpreters for the same thing that we're not getting compensated for?
Sure. And I'd start that question with a lot of those charges on what is billable, the rate, that's all statutory. There are a lot of statutory things, so there's no flexibility here. So the things that we do, again, and I'll just kind of take a side note. One thing that I really admired of my predecessor did was try to add value to the public defenders on what we can do. Any ideas that are in my authority, please give me a call, shoot me an email. I'd love to try to make that happen. And one thing that he did, and even if it's not immediate, but a really good thing is online claims. To cut how long you got paid from 35 days to 17, that adds value to you. That might not add the dollar amount, but that adds value. And how we can add value, I'm really serious about that I really want to do that there may not be a cost impact on us, but it means a lot to you, and that's something that we'd like to do. With regards to that, and that also goes to my original point of Fort Dodge. We are looking at where the attorneys are in the state and how we can most manage that, grow that. Are we looking into that? I'd say we're aware of that. As far as some solutions, we continue to work with the court and the Bar Association on that to see what we can do there. So I appreciate you bringing that to my attention. That issue has been brought up before. So I understand your concern and frustration with that as well, but I appreciate you bringing that up. Okay. Thank you very much for having me. I really appreciate it.
I appreciate it. Thank you. Sorry.